with an application for the disqualification of the bench. Why can't you go to that point instead of beating around the bush, as you'd say?
Well, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My name is Ongoya. I am acting in person. We filed an application for the certificate of urgency on the 8th of October, 2024. Before this bench was impaneled on the 15th of October, 2024. Unfortunately, some of the grounds we were seeking have been overtaken by them. My lord, and today, as you have heard, our application has not been placed before you, and we are just concerned that our application will once again overtake our application. My lords and my lady. So we're asking with the kind of indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam, for the 5th interested party in 15, can I just be heard for 1 minute on my Lord Jadra asked an important question. How do we move forward? But the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Bremer about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction of the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gedumwe guide, there will be greater order and coherence. And I thank you.
But Lord, is that an adjournment? Is that if Mr. Ongoya applying for an adjournment? Because he's saying, and perhaps slightly wrongly, that even the refusal application comes after the termination of the question of empanelment. If that be so, they may leave, they normally leave court, they may leave, they left the Senate, may leave court. Let them say whether they are applying for adjournment.
Is that remark they normally leave court, the left Senate, my palatable in this court, my lord? I mean that.
No, because it's an adjournment.
No, is that remark palatable for my lord and my lady? But because we have decorum at the bar. If you have a professor of law misbehaving at the bar, I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark, but the point is, it is a veiled application for adjournment, because Mr. Ongoya is saying that the court must address the question of empanelment before the recusal. So why can't you just get to the point?
I am answering your question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but he will withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem with withdrawing. Hey, my friend, back. No, I have no problem, my lord. I withdraw the remark, but
Thank you.
there is practice.
Thank you. Let me now address the question. My lord, because again, I was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted, because I can't protect my father's dignity if my own is in question. But having said that, My Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Kido Mungai, and learned colleague, Mr. Ndegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Kido Mungai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly pray.
Leadership, again, you are not to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is down. They actually knew of it, and this, or should have, they would have found out. The letter, which was written this morning, which we have, it was received on it was written on the 20th of October, has actually one pertinent question. It is posing whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted.